Everybody, good morning. Nice to see a lot of you guys make the trip in person. I think you're going to be richly rewarded for having done so. I'm not going to read this; it's going to sound too robotic. I'm delighted to introduce a friend and colleague, Jessica Wood, who is a shareholder at Bodker, Ramsey, Wildstein, Winograd, and Andrews. I think I got that all right. Maybe not the right order. You always feel bad with law firms. Anybody after the first two always get chopped off. I sort of feel badly for them. Jessica is a fantastic litigation attorney and business advisor who I know is very passionate not only about the topic that we're going to hear about today, but also helping people in her profession develop and developing her profession. Yeah, I mean, she holds degrees from Georgia State University, but beyond that, she's very dedicated to making sure that as many of us as possible have the opportunity to work in a place that is non-toxic. And I can't think of anything that is more important, particularly in today's environment. You know, as most of you know, this is the year of talent, and we're now reaching the end of the third quarter of our year of talent. And one of the things that kind of gets overlooked, I think, is the issue that Jessica is going to talk about today, which is, how do things sort of change in a remote environment? Does discrimination still happen? I think we're going to find out the answer is yes. Do microaggressions still happen? I think we're going to find out that the answer is yes. Right. But as so many of us have encountered as business leaders, right, we're in this brave new world of remote work, hybrid teams, digitization, which most of you who know me know that I'm very much in favor. I haven't gone into a steady office for like 15 years now. But it's also not something that's for everybody. But one of the things that kind of gets overlooked, I think, often is that we have this brave new world, but most of us were thrown into it with almost no warning, right? And we had to develop and redevelop everything we thought we knew about business, everything we thought we knew about managing people, everything we thought we knew about creating a work environment that develops talent, that makes them want to stay, that allows them to reach their full potential, to self-actualize themselves. Everything we thought we knew is thrown out the window, right? How do you do that remotely? Now, there's some people that say that you can't build culture digitally. I strongly disagree with that, but this is the forum for that. But there's no denying that just because your employees are no longer coming into your office, that doesn't mean that you're still not in charge of sort of their care and feeding to make them the best that they can possibly be. Jessica's won just about every award that they give lawyers, and some awards I don't think that they give lawyers. She does a great deal of pro bono work, in particular for people that are being evicted, to make sure that they're being given a fair shake. She runs a quarterly event called Water Cooler, which is intended primarily to help baby lawyers figure out the next steps of their career, often to get their first jobs or sometimes their second jobs. Lawyers have a particular, I think, stereotype. Whatever you think that stereotype is, I would urge you to chuck them out the window right now, because Jessica is going to break every single one. And in addition, she's a big fan of New Wave. So for those of you who are in like a modern English fan club, right, I think Jessica can help you out with that. So I've been looking forward to this ever since she agreed to come on about 3 months ago. It is my immense pleasure to introduce Jessica Wood.
So I'm applauding Mike for that fabulous tee up. He and I'm not just saying that because he and I agree on so many things about workplace culture. You may not know this about me, but I'm off the charts extrovert. And no one was more surprised than I was by how much I really enjoyed working from home and being a hermit. And as Mike said, I like all of us was thrust overnight into this virtual world. I live alone in Midtown near Piedmont Park. So my toil every day was just me at the computer answering emails for hours and hours. Actually, and like many of us, I found that, without anything else to distract me, I was working many more hours. I was actually sublimating my own fear of mortality and the endless sad news cycle by immersing myself in work. Turned out okay. Clients had issues. And I do have some strong opinions on some of the topics that we're going to cover today, but I am also very open to you all just popping up a hand. Ideally, I want you to walk out of here today with some new ideas, perhaps reinvigorating your workplace culture. I would love to serve as a catalyst for you to go back into the office as leaders and, support your troops because they need it. I think 100% of us, this is really important for us to remind ourselves of. We are still in a pandemic today. We're not done. We're all sitting here unmasked, which is an amazing luxury. We've all been, immunized and boosted, but we're not out of the woods. And I saw something online about, that 100% of us have experieed trauma. People close to us have died and gotten sick. Aren't you glad I'm here first thing in the morning? Let's just take it way down, y'all. But truly, I would talk to opposing counsel in the pandemic, and I would say, how are you? And then I would really listen to the answer. And I will never forget early in the pandemic when my opposing counsel said, I can't look at Facebook anymore. It's just one obituary after another. And that just hit me in solar plexus like a sledgehammer. It's been said that, all of us were in the same storm, but some of us did it from a yacht. Some of us did it from a leaky dinghy. And so, or some of us were in between. Let's really dig deep and be as empathetic and kind as we can be during this time and forever. Let's be better forever, y'all. I think it's an amazing opportunity for all of us to rethink all of our decisions that led us to here and how we want to go forward. So again, I'm here to darken your day by reciting a parade of horribles that happen in the workplace and that have absolutely skyrocketed during the pandemic. I'm fielding so many calls from, and I don't know how they find me. I always say, what Google search did you do that got you to me? And they're like, oh, sex, lawyer, Atlanta. And I'm like, okay. All right. But sex discrimination, we all know how SEO works, but I'm doing almost a little bit of involuntary pro bono and hand holding with plaintiffs. Employees are calling me out. They got me from a Google search and they're telling me the terrible things that are happening at work. And I will listen. First, I have to do a conflict check, right? For all I know, my client is the one doing the terrible things to them. So I don't want them to reveal anything until I know that I'm cleared to talk, but I will talk with them for a little bit. But I'm spending a lot of my time hearing sad, horrible stories. Everybody in here is a CEO or leader high up on the management food chain. I know y'all haven't done any of this stuff. I'm not accusing you. I know that you are perfect. I know that your workplaces are perfect, but we all know, I think we just learned this in the pandemic. The only thing constant in life is change. So part of this is for future you. You may go to another place that's not so nice, and you may have some messes to clean up. So I want to start you thinking about, what steps can you take today to prevent harassment, and what can you do if it happens in front of your face or you hear about it. As CEOs, most of you delegate employment related decisions. So this talk is not intended to turn you into an HR expert. I just want you to know some of the headlines, some of the trends that I'm seeing and hearing. As I said, so I'm a business litigator. I fight in court, all right? But I also, a lot of those fights turn into transactions or deals. So one segment of my practice is employment. Typically, I do represent the employer, the alleged wrongdoer. They haven't done anything wrong, but someone's alleging they did. So how do I get them out of it? Every now and again, I will represent an employee, but it's rare. And let me tell you why. I want to explain a little bit of a business concept that may help you understand some of the incentives that may fuel an EEOC claim or allegations. So I am an hourly rate attorney. I charge in 6-minute increments. Okay. There are other attorneys who handle these cases for employees on a contingency fee basis. What that means is that the employee does not have to pay them any money. They go in and the attorney's going to represent them and then take their fees out of the back end if there's a settlement or jury verdict. And obviously you can see why these attorneys exist. It's very important that vulnerable people, maybe they just got terminated. They may not have had the money before they got terminated. And attorneys are expensive. I used one time. I mean, it all worked out great. But I'm still friends with my ex, but they are expensive. But as I like to say to my clients who come into me sometimes way too late, pay me 4 figures at the front end and I'll save you 6 or 7 at the back end. You always want to get ahead of things. You don't want to wait till things are take a bad turn before you try to remedy it. But understand, going back to the contingency fee basis, understand a couple of things that are a driver in this space. First, to get an attorney to take the case, it's got to have some good features to it. It's got to sound like it could result in money for that attorney. Otherwise, it's not a good business proposition for them. But obviously, just because somebody walks in your door being represented by counsel doesn't mean that they're going to win. It just means that on their face, you've got some pretty scary sounding facts that may pay off for the plaintiff and the attorney at the back end. And also understand, if they walk in your door without an attorney, that doesn't mean that they've been turned down by attorneys. It may mean that they don't understand about this. Who understands about contingency fee attorneys? If I hadn't gone to law school, I wouldn't know about it. So a lot of people don't even reach out to an attorney because they know there's absolutely no way they can afford it. So don't read too much into it either way. If a plaintiff employee comes to your door with a claim, with or without an attorney, but just understand what the attorney's motivation is. They want to do as little work as possible for maximum result. So some of you may have a work from home option. Some of you may not, depending on the industry. We still have bricks and mortar out there. Our law firm is kind of in the middle, which I think is a beautiful place to be for all of us. I go in 3 days a week. We go in 3 days a week, but we choose which 3 days. So what's happening is we're more intentional when we're in the office. We're going to load that up with seeing our colleagues. Otherwise, if I'm drafting an appellate court brief and I don't want to see or hear anybody, that's something I want to do from home. And I'm sure y'all are the same way. We've all learned a lot about our own individual working styles and what works for us. So I want to briefly describe what's meant by discrimination, harassment, and retaliation in the employment law context. Title VII, as many of you may have heard of, prohibits employment discrimination based on race, color, religion, sex, and national origin. And hang on to your hats for this fact. I don't know if you're going to be able to believe it, but do you know when age discrimination starts? 40. Yeah. Kind of mind blowing. I know. I'm like, you're 40. You're just a tiny little baby starting out in life. No, it's 40. It's 40, and it's been 40 for a while. But just keep in mind, 40 is where age discrimination kicks in. It does. So, great question. It includes orientation. It includes gender identity. It includes pregnancy, for example. But thank you. Very sharp question. Also beware of, there are W-2 employees and then there are independent contractors. W-2 employees are going to be covered. Independent contractors probably aren't. But understand, I have so many very sophisticated people just like y'all come in the door and say, no, she's definitely an independent contractor because we have an agreement that labels her as such. That won't cut it. So if you have an attorney, make sure that you're preliminarily that your employees are categorized in the right grouping. Same thing with exempt versus non-exempt employees, meaning are they eligible for overtime? Must they be paid overtime for any time over 40 hours per week? I see law firms. I represent law firms, y'all, and they they're legal geniuses in environmental law or something else, but they make this mistake all the time. You know, they'll say, oh, our receptionist is on salary. And by the way, employees want to be on salary. No, they'll say she's on salary. Said she's working 80 hours a week, but she's on salary, so we don't have to pay her overtime. Incorrect, inaccurate. So both of these, the exempt, non-exempt, and the independent contractor and W-2 employee are somewhat sophisticated analyses. So definitely reach out to your HR professional and or your attorney to make sure you got them in the right places. Because if someone makes an EEOC complaint, then other issues may come out. And let me tell you, the Fair Labor Standards Act is something you do not want to get on the wrong end of. It is really dangerous. And let's say you underpaid them by $1. Well, they still have a claim. So it's not even the size of the claim. It's the fact that you underpaid them for some period of time. This is how strong the FLSA is. If someone files a federal lawsuit for violation of the Fair Labor Standards Act, you cannot settle that claim. You cannot settle that claim unless you have permission of the Department of Labor that will literally look at the terms of your proposed settlement agreement, or the judge overseeing the case. And so beware, beware, beware.
So why would they continue to think that?
Well, because they can make a lot of money, and there can be penalties depending on whether it was willful.
But you're-
So they wouldn't take a $1 case. That's
No,
it.
you say they can't settle.
They can't settle. They without permission. But here's their incentive. If the judge kicks it back, the judge isn't going to kick it back because it's too generous. The judge is going to say this is not enough. So that's why they would take that case.
Right.
So that, you know, the odds are forever in their favor. So didn't mean to get off on track, but I do want to give you a high level of the dangers. So harassment is unwelcome conduct. That unwelcome conduct is key because we have people, as the kids would say, hooking up at work, and that might be consensual. There are some employers who hit that head on, and they have a policy. And I want you to consider how romantic this would be if you struck up a workplace romance and you had to go to HR and declare it. Like, that makes it pretty official, right? So that neither employee involved in the relationship can come back later and say, no, it was non-consensual. So that is a tack that you could take. You could say, sure, especially in a bigger firm where employees aren't working directly together. One's on the 5th floor, one's on 28. If you have a gigantic firm, then it may not be a problem for you. So consider the numbers of employees that you have when thinking about those kinds of terms. So harassment becomes unlawful where enduring the offensive conduct becomes a condition of continued employment, or the conduct is severe or pervasive enough to create a work environment that a reasonable person would consider intimidating, hostile, or abusive. It includes unwelcome sex advances, requests for sexual favors, remarks or alleged jokes of a sexual nature. So people should stop trying to be funny on Zoom. First of all, it ain't funny. Secondly, it's horrifyingly unoriginal. And by that, I mean, LOL, you don't even know if I'm wearing pants. No, a billion times no. One manager saying that at one meeting does not an EEOC claim make, but that's the kind of thing that if you see it or experience it, clean it up. Talk to that person and say, nope, not funny, get better jokes. And how about just focus on work? Also in the pandemic, this has skyrocketed. We've seen it on the streets and we've seen it inside our offices. There are those who will make demeaning or derogatory remarks directed to employees who are or are perceived to be of Chinese or other Asian descent, including remarks about the coronavirus or its origins. So be on the lookout for that. It's dangerous, it's horrible, it's othering. And obviously, an employee who is targeted for those kinds of remarks could reasonably be in fear of their lives. We've all seen what has been happening on the streets. It's very dangerous. Anti-discrimination laws also prohibit harassment against individuals in retaliation for making a claim, or in retaliation for being a witness in a claim, or perhaps complaining on behalf of another employee who feels too vulnerable to speak. Important to know about retaliation. Y'all are familiar with it's not the crime, it's the cover-up. A lot of times with these EEOC claims, it's not the claim, it's the retaliation that's going to get you. The retaliation is what you're going to pay for. So important to know, your company can be charged with retaliation, even if the underlying claim was bogus or had no foundation whatsoever or was weak. You can also be charged with retaliation if the person complaining is not the employee who is the victim. It can be a bystander, it can be a witness. So watch out for retaliation. So discrimination, harassment, retaliation, they can blend in together and look like the same behavior. We learned in the pandemic, it can happen via Zoom, although not today on this Zoom, via text, email, Slack, telephone calls. It could be an emoji. We all understand the concept of keyboard warriors. We may have fought with some of them online. But basically, when you are behind a keyboard, you may do and say things that you wouldn't ordinarily do in person. And there's a certain informality that we saw in meetings when we were all working from home in fear of our lives. Unfortunately, there are people out there who will weaponize that informality and cross boundaries. So be on the lookout for that when you have Zoom and other meetings of this type. But
So I'm surprised how many companies don't have texting policies. Because almost every workplace now, people communicate by texting and there's no monitoring of it. Like in an email, you can pull out everybody's email. Like as a scout leader, we're not allowed to email scouts directly. We have a group text. I mean, we're not allowed to text, it has to be a group. But no workplace I know of has any texting policies like that.
and none that I'm aware of. And
you
so
can just screenshot stuff.
Yep.
and-
so at my law firm, I'm an attorney, and all of my most of my communications are attorney-client privileged. Not when I'm talking with opposing counsel, obviously, but I often tell my clients, please do not text me. First of all, it stops them from becoming overly familiar, so I don't get something at 3:30 in the morning. But secondly, I want it to be embraced within my security system. I don't want any leaks. But you're right, Cordelia, and our law firm does draft employment manuals for our clients. We try to keep them short and sweet, but that social media policies and things of that ilk, definitely an anti-discrimination policy, are issues that I would consider to be key. We do very short, like social media, thou shalt not. But I can tell you, I believe in general, if it ain't broke, don't fix it. You never want to condescend or talk down to employees. So if your employees are behaving and it's not a problem, obviously I always want to I'm trained to think in case of worst case scenarios, which is what makes me such a blast at parties. But if you're not seeing those worst case scenarios, then you don't necessarily need to conjure up the problem and go, oh, by the way, don't do this horrible thing that you haven't seen done yet. Does that make sense? But yeah, an anti-texting policy, I think is so easy and so quick. Did you have a question?
It brings back to the question about relationships and having a policy. I would think it would be better to be silent. I'm just in that scenario, if two people were in fact consenting, but they didn't go forward to HR to say that they were consenting, and then one then decides this has gone awry because they didn't go and say that we're official. Now I feel like it would be more open to say, well, we never, both went forward. Like, is it better maybe to be silent?
It depends. It's very contextual, and it depends on your your culture, you know, the employees, we don't. So this is when we are representing people and drafting these kinds of policies, we are really partnering with you. You're the expert on the facts. We're the expert on the law. I have definitely seen cases. I have a case right now, actually, where two employees, he says they had an affair and it is no longer, it concluded. She says, absolutely not. We did not have an affair. There was nothing consensual happening ever. So that guy would have wished for such a policy. That would protect him now, because now she's saying, no, this is an pure invention. But then the text. I've had a lot of cases. I represent professionals, and the alleged harasser will come into my door and, did you ever touch her? Did you ever kiss? Like anything at all? Is there anything I should be concerned about? Absolutely not. Nothing ever happened. Okay, is that your final answer? And sometimes I will literally say, so I just want to take you through a hypothetical. What if? Because there's audio tapes, there's videotapes, and there's texts, and they will come for you, and it will not look good. So, you know, so sometimes, depending on the scenario, the person who is the alleged harasser may be better off saying, yes, we had a consensual relationship. Here's where it gets complex. I've also had men come through my door and say, because I always say, what's your goal? What's the goal of your representation? And I have more than one man who has come in with the goal of, they're the boss, so they're not going to get fired. Their goal is to save their marriage. My wife absolutely cannot find out about this. So when we're talking about these consensual relationships, it's one thing about if you have two single people, it's quite another if one or both of them are married, then things get weird real fast. Because then both sides are kind of disincentivized. You know, both sides want to say, oh no, that never happened. But going back to your initial question, sometimes yes, sometimes no. And again, if it ain't broke, don't fix it. It kind of depends on what scenarios you've lived through.
There's another reason too,
Yeah.
why some companies frown upon these even consensual relationships. And that has to do with favoritism.
Absolutely.
So, I mean, we had a policy against it, especially two people in the same division or the same group.
Yeah.
Because somebody might complain, hey, she's getting favored because she's going out with such and such, who's a friend of the boss.
Yep.
And so that can become a big problem too.
Yes, and at least once a year, I get a call from a genius client who says to me, it's always the boss, hey, I'm the boss. I have fallen in lust with a woman who is my subordinate.
Yeah.
And I've come up with this cool plan where I can date her free and clear. By the way, she doesn't know that I'm lusting after her. I can date her free and clear just by firing her. See the problem? And I'm like, please stop. It is really proactive, but it's proactivity with a vengeance. But again, I can't emphasize this enough. All of my clients are like geniuses of industry, but they come up with these plans where it's like, this has never happened to anyone else before, and no one ever thought of this. And that's plain retaliation right there. So goodness gracious, don't do anything before you call your attorney. So the other thing that's happened in the pandemic is that because offices are more sparsely attended, sometimes people are more vulnerable because there are fewer witnesses and bystanders to keep the problem at bay. The one thing that hasn't changed is vulnerable people are still vulnerable. You know, healthcare, hotel, agricultural workers are more likely to experience sexual harassment and assault. Of course, we know about healthcare workers. We know what's happened to them both inside their workplaces where even their own patients are screeching at them and behaving horribly to them and threatening them with death. Can you imagine? And they're also getting it in parking lots and on the streets. I've talked to a bunch of healthcare workers who have had to change clothes out of their scrubs before they go home for the day, so they won't be targeted. And certain employees remain vulnerable during the pandemic. This will surprise no one. Harassment was more likely to be experienced by employees who are Black, Asian, Latinx, Indigenous, female, and non-binary, and particularly those employees who maybe belong in more than one of those categories, intersectionality. There have been online bullying. And again, this is shocking. It's more overt, but it can be more nuanced. But imagine, in-person bricks and mortar, boss yells at employee and maybe no one's around to hear it. In the pandemic, there are people who will behave, in just abominable ways to their employees in front of everyone. Or there are people who will say improper things in the chat. They'll just drop an allegedly, again, humor gone wrong. People don't understand what humor is. Offensiveness is not humor. They will just casually drop a sexist or a racist link in the chat. So I would ask that you guys monitor that kind of stuff. Restaurant workers, oh my gosh. So when you hear people say nobody wants to work anymore, I want you to think about healthcare workers and restaurant workers and teachers. No, nobody wants to have their lives threatened to go to work anymore. That's what's going down. Guess what? Restaurant workers are predominantly women. So there's already a vulnerability. There was a study of food service workers that reported a spike in sexual harassment, while at the same time, 86% of those responding reported lower tips. So why would you continue to do that? Also, these vulnerable younger people were also charged with enforcing the mask protocols and COVID protocols, and still are, and they suffered abuse for it. Comments like, pull down that mask so I can see if I want to take you home later. Take off your mask so I can see how much to tip you. Take off your mask so I can do X with this body part. You can imagine. Those are the kinds of comments, not from your table, but maybe from the table over. No surprise, many sexists are also anti-Semitic and also racist. Okay. There was a story in this report about a woman who got, she reported that the customer drew swastikas all over his check. She banned him from the restaurant because she's awesome, but she didn't feel that was enough. So she figured out where he worked, and she notified his employer of his abusive behavior in hopes of stopping a similar incident elsewhere. But this particular example is instructive. If you're an employer, you are in a position to protect your employees from each other, but also, real importantly, from a vendor, a client, or a customer. You're on the hook, Title VII wise, if those outsiders come in and harass your employees. So watch out for that. The customer is not always right. The customer has never been right, not abusive ones. I fire clients for abusing receptionists and other staff. And real important, don't think to yourself, well, he's always been nice to me. Well, find out how he treats other people. We all know, and this goes back to the food service workers, we all know that you can learn a lot about somebody's character by how they treat other people while no one else is watching.
So, can I ask a question? What
Sure.
responsibility does an employer have when a vendor is harassing an employee?
To make it stop. And that may mean having a sit down with their boss, having a sit down with them, and you cannot darken our door again. You cannot interact with us, or you fire that vendor and find another one. But you see to it that that person does not have access to that employee.
I have a question.
Sure.
As well.
Sure.
What percent of your discrimination cases are cases that are clearly perceived discrimination where there is none? For example, someone who is a lousy employee is fired. And then alleges, the reason is because I'm a minority, I'm a woman, I'm whatever.
It happens all the time.
You know, I mean,
It happens all the time, but most of us are not in the room. Most of us, it's not reported. So is it true or not? We're never going to get to the bottom of that. But let me give you a tip that will help you be less vulnerable to that kind of stuff. Okay. Be truthful and give your employees constructive criticism. I cannot tell you how many times someone's on the verge of getting fired or they just up and decide they're going to leave. And then suddenly they say, I've kept this under my hat for a long time, but I was sexually harassed the whole time. And then I go back to the client and say, what say you? And they're like, she's been underperforming for years. She's been underperforming for decades. So my first question is, why? Oh, why is she still there?
Okay.
And then here's the tough part. So get ready. Then I say, can I see her personnel file? And do you know what's in that personnel file? Glowing accolades.
Yeah.
She got a raise every year.
Yeah.
She's 10 out of 10. She hit the metrics. So that doesn't mean
That's
that
a good point. It's important to give warning,
exactly.
but back to your.
But the truth needs to
Yeah.
align with your paperwork. And I'm not even talking about CYA.
Yeah.
If the reality is people think they're nice by not saying, well,
Right.
actually, she's not that great, but I don't want to hurt her feelings. Well, no HR professional is going to let you do that. You must. It is cruel to keep someone around
Yeah.
if you think they're underperforming and you've never said it to them. That is on
Yeah.
you. You're hurting the employee.
Yeah, that's bad management.
Yep.
But let's take a simpler case. And
Okay.
you brought up masks. Maybe 6 months ago, I really asked somebody to take the mask down. And it was because A, they were mumbling, B, in a foreign accent, C, behind a mask. I couldn't understand what on earth they were saying.
Was this an employee?
No, it wasn't. But I didn't do it because I wanted to see their face. I didn't do it because I was anti-mask. I just couldn't understand what the hell they were saying. And
I gotcha.
I don't know, but probably other people have had that same
So a
experience.
couple fixes for that. Go outside.
Yeah.
Everybody takes their mask off.
Yeah.
Or,
Yeah.
communicate remotely. I mean, this is the virtue of remote, right? It saves money. It saves travel time. Y'all, it used to take me most of a day to show up in a hearing in Gwinnett County that was going to take me 15 minutes. And now I'm saving the client all of that money. It's almost magical. I could appear in this court here and 2 seconds later appear in this court over here. But I understand your
Yeah.
point. But on the mask piece, we're all navigating this together. We're all in it together, but just get to a place where you really can understand them. I have clients who really want to see me face to face, but I tell them we're all going to be masked up. We're going to take your temperature and you've got to fill out a form. You sure you don't want that to be remote? And a lot of times they insist, no, I want it to be in person. But yeah, I hear you on that.
Quick question. Normally, well, almost all the time, fire somebody to get 80% off of it, because then they will fight the legal battle for us. That's the normal process. The other thing that we will sometimes do is have people sign in exchange for severance or release of the
Sure.
plan.
Absolutely.
So how ironclad?
The releases,
Yeah.
if I draft them, ironclad.
That's what-
It's going to say, I hereby release you for
oh, yeah.
any and all claims or sins of the world from the beginning of time to today.
So once we get that signed.
Yep. Yep.
That's what.
Yeah.
Do not draft it yourself.
Oh, no.
You can't actually, or release it. They just release their.
Yeah.
So you can still have a DOC.
Yeah.
Yeah. Good point. Thank you. But yeah, the other thing is if a client comes to me and they say, I've got these claims, and in addition to the personnel file, one of my first questions is going to be, can you show me your employment manual? And maybe you have one, maybe you don't. If you have an employment manual, do you have an acknowledgement that they read and received it? And sometimes you do it a couple times a year as you update policies, which is always wonderful. But then their employment agreement, do they have? And this is another danger that is often uncovered in the EEOC realm accidentally. I'll look and I'll see, oh, they've got a non-compete. They can't do this anywhere else in the world. Or a non-solicitation. You're laughing. Why? Because you know it's unenforceable. So you asked a great question about ironclad. Well, can you draft a non-compete that will be upheld by court? Yeah. I don't know if you know this, but there was a whole statutory framework enacted May 11, 2011, a day that will live in infamy in the legal employment world, where statutorily there are rebuttable presumptions. So there's a rebuttable presumption that this length of time for a non-compete is reasonable. Reasonableness, commercially reasonable is the standard. There's a rebuttable presumption that this geographical area will work. And typically what we do is we may actually say, thou shalt not work for the following competitors, see Exhibit A. So it's ultra clear. But it could also be within the territory in which the employer worked during the time or during the tenure of employment. Ideally, you take what we would call the belt, suspenders, and bungee cord approach and do both of those things. The point for any of these contracts, including a release, is clarity, 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 and sometimes make them short. Because again, much like the employment manual, you actually do want people to read these things. You want them to get the highlight. But how many of us in this room have read our employment manual? But I'm an attorney. Other thing, in addition to the employment manual, understand that could be there. We're talking about Title VII claims. There can be other claims. There could be intentional infliction of emotional distress, obviously workers' comp. There can also be defamation. You want to watch out for that, as well as breach of contract. If you, going back to that employment manual, you got an employment manual and that individual signed receipt of it, and you've got a hiring letter. Sometimes you make promises in the hiring letter that do not come to fruition. So now you've got a breach of contract claim. And you may, deviation from protocol could be a sign of harassment, discrimination, or retaliation, but not necessarily. We treat differently situated employees differently based on their, based on how long they've been with the company, their loyalty, for example. So say you've got somebody with hundreds of hours of PTO and somebody said, yeah, we'll pay that out to you when you retire. And then you have a new PTO policy where no, you can't roll things over. Well, then I would look at that scenario and ask, in a contractual sense, does this one employee have just a different deal that was worked out? So beware of making different deals with different employees. Don't do it unintentionally. If you do it intentionally, that's fine. Because different folks have been there longer. Maybe they've got a ton of sick time, whatever. Look and see if they've met the metrics, and maybe they are deserving of a little more wiggle room than other people. The main thing is you want to make sure that if an employee is treated differently, it's not super positive like favoritism like you're talking about, or super negative like the harassment and retaliation that we're talking about. How much more time do I have? I want to
Yeah, you're near the end, so.
Okay.
Wrap up. Do we have, Mike, do we have any Zoom questions? Is there anyone who's have a question?
Let me ask you a question on the non-compete.
Mhm.
Can you get around a non-compete by having your new employer write you a letter specifically saying that you are being offered the job?
yes and no, yes and no. The employer, so you, the employee, if you have an agreement, you might get breach of contract. Your new employer might get tortious interference. Tortious interference leaves you, breach of contract, you can't get punitives. Tortious interference, you can get punitives. So that the new employer who's vouching for you, and there are superstar people, and I've seen those, that kind of vouching, but it's gonna be, they're vulnerable, and you still are too. I mean, you have to think about how would this all be reviewed if y'all wind up in court. There's also in the trade secret world, there's a concept of inevitable disclosure. And what that means is, so let's talk about our beverage manufacturer here in town. Let's say you work for Coca-Cola for a number of years. The Coca-Cola, thank you. And then you go to a competitor. And let's say you worked on a new Coca-Cola product, and you go over to the competitor, and what are you going to say? Oh gosh, none of the secrets in my head that I got from Coca-Cola are going to come out. And I think Coca-Cola would have a strong argument. It's inevitable, given that you're playing the same role. You're in R&D, you're inventing new flavors. So no can do. Important point about trade secrets: they can be protected in the absence of a contract. You don't need a contract, but you should have a contract, because the contract is the way that you show the court, oh, we make all these employees sign these to protect our trade secrets. Also, in the pandemic, work from home, work from anywhere. Think about where your laptops are going, and think about where those employees are working. Yes, they might be working from a beach. Does that mean somebody can come up and look over their shoulder and see the formula for Coca-Cola? I don't know, but that would be something. If y'all don't have employment manuals, I would ask at least consider doing anti-harassment and doing something about non-disclosure. My experience of humans and employees is that they want to do the right thing. They're not all feral, but you have to guide them, and you have to be really, really specific. And you have to tell them who has access to this level of document, and make sure that you use your tools, the computers, where literally there's a certain level of employee who cannot get to that document, even if they want to. Also, if somebody's walking out the door for any reason, exit, look at their emails, because I cannot tell you, there's nothing new under the sun, including employees who will send trade secret stuff to their Gmail account 2 weeks.
Amateurs.
Oh my gosh, but they always think they're the first one. Oh, there's no, and then you'll see texts to other employees. There's no way they'll ever find out about this. LOL. That has happened more than once. This is why we look at text. All right, y'all. Thank you so much for having me today. I've really enjoyed meeting you, and thanks Cordelia and Mike for inviting me. And your organization is really stellar and really impressive. I love all of the good works that you're doing in the community, and I know that that